Do you know if a sex offender logs on, do they have to let everyone know that they're a sex offender? Is it sort of like a virtual version of going door to door? We're going to talk about Packingham versus North Carolina, where the court ruled that a state law prohibiting convicted sex offenders from accessing social media websites violated the First Amendment.
And the law basically said you can't go on any sites where children are allowed to be on. So that basically blocked them from a lot of social media sites like Facebook, Twitter.
Although I don't think any kids are on Facebook now. Apparently it's all old people.
Yeah, maybe not. But anyway, they argued, sites like Facebook and Twitter had become sort of the medium of communication, and it was an overbroad response to the concern about sex offenders being able to prey on children. So they basically said that if you want to write a narrower law, such that, punishing, contacting children on these websites or something like that, that would be okay. But to just broadly ban registered sex offenders from getting on these sites, they've become such important modes of communication that they just had to take care to write a law that targeted the problem more deftly.
Do you know if a sex offender logs on, do they have to let everyone know that they're a sex offender? Is it sort of like a virtual version of going door to door?
Not to my knowledge.
Would you have a First Amendment right to track down sex offenders and publish information about them online? Is that okay to do?
Well, that's interesting because that raises the question of whether you have the right to gather information in order to publish it. And the publishing part is the free speech part. So lower courts are sort of all over the map. They sort of recognize what's called a news gathering privilege. And it was mainly designed for journalists, but now that everyone can be a journalist on the internet, it's not inconceivable that somebody might try to take advantage of that news gathering privilege that lower courts recognize.
Just trying to get into the mind of a sex offender for a second. It would take me longer to get into the mind one because I'm very far from it. But the idea that I wonder if you would even want to fight that in court, because it would probably bring more attention to you if you were actually going to fight that. I've been getting a lot of, robocalls. People calling me up from China. There's always a woman named Brenda who's calling me up and wants to talk about car insurance or student loans and that sort of thing. How do these people get my phone number, and do I have any recourse whatsoever to make them stop?
Well, I don't know how they're getting your phone number.
Did you give my phone number out?
I didn't, I promise. But the government has passed laws, banning robocalling. The court has basically said, look, most speech is fully protected speech, but there are certain categories of speech that don't get as much protection, that the government can regulate more easily. Commercial advertising and related type of speech is sort of one of those lower forms of protected speech. Mm-hmm. And so, robocalling laws are generally upheld on that basis.
Now I'm wondering if we combined robocalling with somebody outing sex offenders who live in your neighborhood. Like, hey, don't hang up. My name's Brenda, and there's a sex offender next door to you. In Europe, they have right to be forgotten laws. The goal is basically if people want to scrub their past for things that they don't want to be remembered for, that, could stigmatize them in the future. I'm betting sex offenders probably love those right to be forgotten laws. What do you think about those?
If Congress were to pass a law basically saying that you had to remove certain speech, that would be like a restriction on speech based on what a person wanted to say. And again, the court subjects laws that restrict what you want to say to intense judicial scrutiny, and so it probably wouldn't be deemed constitutional.
And I wonder just how they go about doing it, how they go about getting rid of that information.
Actually, there was a case where the Canadian Supreme Court ordered Google to essentially delist from its indexes a certain company that was promoting false advertising. And Google complied in Canada, but said in the U.S. we don't have to comply. No.
Although I would say, for most sexual predators who are looking to go online, they probably want to start with a clean slate.
Maybe, but I I doubt that even European right to be forgotten laws would allow sex offenders to remove that sort of information.
Barry, would you like to forget this interview ever happened?
Well, no. This is fun, Lou.
Thank you. I needed to hear that so badly. Hey guys, I hope you enjoyed our video. If you have any questions about the First Amendment or free speech in general, let us know in the comments. And be sure to subscribe to our channel and make sure to click the little bell icon so you get notified anytime we release a new video.